Thank you very much. Firstly, I would like to express my gratitude to Adam and to Professor Zoltan for invitation for this event. I'm glad because I'm not a philosophist or theoretic of law, rather constitutionalist, but I would like to share with you some thoughts that are connected with theory of law, but also with the practice. Monism and dualism. What could we do about the law in the world without the center? It is often said that in early decades in the 20th century, two distinguished jurists met once in an academic gathering and debated whether law could be ever be one and indivisible. One believed that the unity of law could be proved by logic alone. The other insisted that in the world of sovereign states, such unity was an illusion. History remembers their disagreement not merely as an academic quarrel, but as a symbol of a deeper question that still resonates today. Can there be one law in the world that has no single center? The old debate between international and domestic law was never only about the legal technique. It was always been a philosophical inquiry into the nature and unity of normativity itself. Is law a single coherent system or constellation of autonomous yet communicated words? In monism, it was claimed that law is one. In dualism, it was replied that law is many. Yet, in 21st century, we find ourselves in different landscape, in different geography, political geography, in different meaning of state, power, sovereignty. Law has become a network, a web of constitutions, treaties, judgments, and regulation that constantly overlap and reinterpret each other. It is also not only hard law, but also soft law. It is said that sovereignty is no longer an attribute, it is a relation. And if sovereignty is a relation, then law too ceases to be a structure. It becomes a conversation. At the end of the 19th century, Heinrich Triepel argued that international and domestic law were two distinct systems. International law bound states, not individuals, and domestic law operated with the boundaries of sovereignty. For the treaty to have internal effect, it had to be to transform into national legislation. And this understanding is applied in many constitutions nowadays in Europe. On the other hand, Hans Kelsen, the architect of the pure theory of law, rejected this duality. For Kelsen, all norms belonged to one hierarchical system grounded in a Grundnorm, the fundamental presupposition of validity. And there are no, Kelsen said that there were no two systems, only one, and the only question is, does the legal order derive its authority from the Constitution or from international law itself? I think that today we are still asking this question. On paper, both theories are elegant, but paper, as we learned, does not account for politics. After Second World War, both models began to erode. The law changed and the world with it, or opposite, the world changed and the law with it. First, international law ceased to be merely interstate. It became law for individuals through the United Nations Charter, the Universal Declaration of Human Rights, and countless conventions that directly bind persons, not just states. Second, the regional integration, especially within Europe, produced a new kind of law, supranational law. In European Court of Justice verdicts, for example, Van Genen laws or Costa versus Enel, the community law, the Court of Justice said that community law constitutes a new legal order, directly effective and supreme over national law. Neither monism nor dualism could easily explain that reality. Even if when after the Lisbon Treaty, European Union became international organization, the problem wasn't resolved. First thing is the globalization and proliferation of legal regimes fragmented the landscape. For example, environmental law, human rights law, trade law, security law, principles, new procedures, not enacted only in the state, but in different centers of legislation. Today, international law resembles not a pyramid, but a network of interwoven orders. As Jürgen Habermas noted, national sovereignty has been internalized within international law. And once sovereignty itself becomes rational, the old binary models no longer suffice. Before turning to the new theories that seek to make sense of this transformation, let us pause and ask what actually changed. Why did the old logic of monism and dualism begin to fail? There were, I believe, 4 decisive shifts of it. First, a historical shift. After 1945, international law was no longer a gentleman agreement between states, but a community bound by the memory of the catastrophe of war and totalitarianism of 20th century. Human rights became no mere ideals, but legal obligations, and law began to speak directly to individuals, not only to governments. Second shift is institutional shift. The creation of United Nations, regional organizations, and later European Union produced new centers of authority that did not fit into this pattern state international binary. Between the national and the global, a new layer of supranational legality emerged. Third, technological and economic shift. Globalization, digital networks, transnational markets have woven the world together faster than any treaty could. Legal norms now circulate through commerce, algorithms, and environmental governance. In the previous session, there was a question if this violation of law of goods in cyberspace without regulating it as a crime should be punished. So here also is the problem. Fourth shift is a moral and philosophical shift, a growing recognition of that legitimacy cannot rest solely on the concept of the states, and in the post-national constellation, authority must arise from communication among equals, not commands. These four shifts, historical, technological, institutional, and moral, opened the way to pluralism. They made us to realize that law no longer has a single home, no single decisive center, but this law lives simultaneously in many places. And that realization gave birth to the new theories: constitutional pluralism, interlegality, transconstitutionalism, which no longer seeks one foundation for law, but rather a grammar through which multiple foundations can coexist. To capture this new world, some scholars have proposed the idea of constitutional pluralism. In this view, there is no single center of legal authority. Instead, multiple sides of legitimacy coexist, connected not by subordinating, but by mutual recognition and dialogue. Kirsch reminds us that the absence of hierarchy does not mean the absence of order. So he said that without hierarchy, order is possible. Then Walker said that pluralism is not disintegration, but it is interdependence. And Kuhn describes as a cosmopolitan constitutionalism of dialogue, not domination. Indeed, the conversation of courts has become the living grammar of global law. And this courts activism was and is the sign of it. But the question is it conversation, dialogue, or maybe it is a monologue? For example, German Constitutional Court declares that European law applies as long as it protects fundamental rights, this Solange verdicts. European Court of Justice respond, but we are the guardians of EU treaties. And for example, Polish Constitutional Tribunal or Italian said yes, but for us, the constitution is supreme act, so we have to follow it. From this exchange emerged not chaos, but dialogue order, law as ongoing translation among systems, but does it solve hard cases? What we witness is more than institutional change, it's a transformation in rationality of law itself. And so let me say it's clear, monism and dualism were two great languages of 20th century, elegant but obsolete, not because they are wrong, but because the world no longer speaks in one language. Today, law is polyphonic. It is difficult to point out single Grundnorm because there is a web of mutual recognition. There is not absolute sovereignty, there is shared sovereignty, shared authority. And perhaps this is precisely what makes the law resilient. In times of uncertainty, the law needs less hierarchy and more conversation. So perhaps this is where we stand. The central question is no longer who has the last word, so where is the center, but who can still listen in the language of law. Law has ceased to be monologue of the sovereign. It has become the conversation of many participants. In Poland, we have a concept of multi-center legislation system. And then that conversation continues in Luxembourg, Strasbourg, Karlsruhe, Budapest, Warsaw, Rome, etc. And in each courtroom, in each judgment, echoes of the same dialogue that began over a century ago between the ideal of unity and the reality of diversity. It is no longer about which law is higher, but sometimes this parts of the dialogue forget about it, but it's about how different laws can understand one another. In the monism and dualism, both fail to capture our legal reality. The task is not to choose between them, but to rethink what unity means in law. What we need is not another model of integration or hierarchy, but the model of relation. A relation theory of law would rest on three simple ideas. First thing, law as interaction, not structure. So a law as a network of practices, a process of coordination between actors and institutions across multiple levels. And its unity is achieved through translation, not through control. The second element, legitimacy through recognition. So it means that the validity no longer comes from a single sovereign source, but from reciprocal recognition among legal orders. And the norm is valid because it is accepted across communities that treat it as a part of their shared legal grammar. Back to customary law. And third, coherence through dialogue. Instead of asking which law prevails, we should ask how laws communicate. The health of the global legal order depends not on uniformity, but on the quality to conversation that sustain it. In the same sense, the unity of law in our century is relational, procedural, and dialogical. But it is built not on subordination, but on intelligibility. And the true challenge is no longer to define the borders of law, but to cultivate the ethics of translation between so many voices. And perhaps this is what comes after monism and dualism, the world where law is not one and not many, but connected. And no vision of the new legal order can ignore the state. For the state remains the primary site where law takes shape, gains legitimacy, and meets the citizens. And the mistake is to create sovereignty as a thing, a possession, rather than as a function within a web of relations. In classical theory, sovereignty means the final authority to decide, called the power to determine the exceptions. But in rational age, sovereignty becomes the capacity to participate, to engage responsibility within overlapping system of governance. And the state no longer disappears, it evolves. Its sovereignty is not abolished by international law, but meditated through cooperation and mutual recognition. And sovereign state today is not the one that can act alone, but one that can act meaningfully with others. And sovereignty has become post-sovereign, not less real, but distributed and communicative. The state does remain the cornerstone of the legal order, but its legitimacy now depends on its ability to translate the domestic values into language of shared norms and to allow international commitments to be interpreted within its constitutional identity. In this sense, sovereignty and pluralism are not opposites. And they are two sides of the same ethical project to hold power accountable in the world where authority is shared. And again, law should be a part of our communication. But there is one question, and this question will rest if there is today need to have this Grundnorm that Kelsen described, and what is this Grundnorm today to help us to communicate on the basis on the same values. Thank you very much.